I get calls all the time from people that are concerned about their first court appearance, and they're wondering what will happen if I go in and I say that I am not guilty, but really I am guilty. Will I get in trouble for lying to the court? And the simple answer is no. You will not get in trouble by going into court and saying that you're not guilty, even if it's your intention later to change your plea to guilty. All you're doing by saying that you're not guilty is you're telling the judge, Judge, I want more time to review the evidence. I want more time to look at the case that is against me. I want to know exactly what my options are. So I'm pleading not guilty at this time so that I can review my options. So that there's absolutely no penalty whatsoever in pleading not guilty at the very beginning of a setting. You have the right at any time, however, to go into court and say that you are guilty, that you do not have to go to trial. You can say, Judge, I'm guilty and I want to be sentenced. The problem with just pleading guilty to the court is that that subjects you to the full range of the sentencing range for the given crime. So for Class 4 felony, for example, you could be facing 4 months in prison up to 3.75 years in prison. That's the range of prison time. You could possibly get probation under some circumstances and not others. And so by just pleading to the court, you're throwing yourself at the mercy of the court. A good criminal defense attorney should negotiate a plea agreement that gives you some amount of certainty, that gives you some idea as to the range of what you're facing. And ideally, we want the range to be as low as possible and as narrow as possible, because a range of 4 months to 3.75 years doesn't really give you any reasonable degree of certainty. The problem with it is that it's not the judge, it's not the defense attorney, it's the prosecutor who makes the plea offer. And the prosecutor can just decide, you know what? This is the plea offer. It's never going to change. You could hire any defense attorney in the world. It's never going to be modified. This is what it is. Now, gratefully and thankfully, not every prosecutor has got that worldview. And there is actually a way to take a letter to that prosecutor's supervisor asking for a deviation or asking for a better plea agreement. But that's a formal process. It's got to be in writing. It's not just a phone call. And there is a method to getting a good plea agreement. So if you're facing felony charges and you're at the beginning of the process, I urge you to really start looking at what your attorney is doing. Has a deviation request been filed? Does your attorney have all of the mitigation or all the evidence that they need to show that you deserve a good plea agreement? Letters showing that you've got support in the community. Do you have everything that you need early so that the pressure can be put on the prosecutor to make the plea agreement work? Many prosecutors will issue a deadline. And they'll say 30 days prior to trial, it's a plea cutoff deadline, it is what it is, and after that, don't ask me for a plea because I'm not going to make one to you. And a lot of people are unaware of that fact, and so when they learn that there's a plea agreement, they may only have 1 or 2 days to think about that plea. And then a lot of times, if you're pleading to a case where it's a prison plea, you may have to go into custody that same day that you plead guilty. So the lines of communication between you and your attorney need to be wide open. And there has to be a very, very good idea as to what kind of exposure are you looking at, what kind of jail time are you looking at, if any, prison time, and then what are the deadlines? When is the drop dead date? When is the date where it's either take the deal or go to trial? Unfortunately, a lot of people just don't have time to think about the plea agreement, so they reject a plea agreement, they then change their minds a couple weeks later, but then it's too late. So if you are in that predicament right now where you're facing a deadline, I urge you, now is the time to call. Don't wait for that deadline to come and go. 602-989-5000 is our number. 602-989-5000, and we're happy to look at your case, review it for you, and give you an idea as to what it is you're facing. Thank you so much.